Welcome to Sweeney Show, Business and Law Podcast. My name is David Sweeney, and joining me here today is William McLoughlin, barrister. William, you're very welcome.
Thank you very much for having me.
So William, you're based, is it Eastern Circuit in Dublin?
No, Dublin based.
Okay.
I'm a barrister. I've been practicing around 10 years now, mainly in obviously the usual personal injuries, judicial review, planning, a bit of probate, but a lot of data protection. That's a big thing that's exploded in the last couple of years. So
Oh, yeah.
obviously why I'm here today.
Yeah, great. And we'll get into that in a second. So could you just explain the process, or what's your legal background? Is your undergraduate in law, or how did your journey to King's Inn?
This is like a real interview now. Am I applying for a job in your office? Am I?
No. Well, it is interesting. People are interested.
I
Yeah.
started off in corporate sales donkeys years ago in Aircom, and my primary degree was business studies marketing. I ran my own business for a few years in retail, fast food outlets. So really ran my own businesses. And then I hired a barrister for a particular incident, and the opinion was like a page long, and I went, I can do better than that. So I went to the King's Inn to study it. And then loved it and started doing law. Practiced around 10 years now, and I had to go and do the King's Inn's course in the evening, which is 2 years for the postgrad diploma, higher diploma, and then the 1 year degree on top of that, which I think is now 2 years.
And you think that real life?
And that was it.
Yeah.
Hard work.
Do you think that real life experience in the business world has helped you?
Oh, big time. It's more practical because from my experience, and again, this is more the practice side of it, nobody wants a lawyer who says, no, you can't do things, you can't do this, you can't do that. What they want is people to kind of give them options and solutions and give them ways of doing things and weighing up the risks. So obviously, if a client comes to me and they have difficulties, I give the options, I can weigh up the risks and give them, identify the risks and what they could or couldn't do. But it's their choice at the end of the day. And as long as I give them practical solutions, and as long as obviously they're legal and what they want, and it takes into account their needs, and give the options, but then it's their choice, as opposed to lawyers just coming in and going, no, you can't do that, you can't do that.
Yeah.
Well, let's find a way of doing things if we can. And that's how I initially got into judicial review, by coming up with practical solutions to issue. One of the big ones I got was I got the first license for cannabis for chronic pain in Ireland. And we were setting up judicial review for patients.
So just for some of
we set it up too well, so we couldn't give the minister or Department of Health a way out. And I was like, yeah, we got the license. Like, oh, after judicial review, it's gone now. We did it too well.
Yeah, but just for anyone that might be watching this, what is a judicial review?
A judicial review is where you basically challenge the decision of a state body or an organisation acting like was a judicial function. It's usually an organ of the state or a state body or state department over something. Over an administration decision, and it is not an appeal. You're challenging the way the decision was made, as opposed to I just don't agree with it. So if the decision was made and you don't like the result, well, tough, you can appeal it if you want. But judicial review is where you're challenging how the decision was made. Was it made in accordance with the law? If so, which law? Was it all done properly? Was due process followed? Where applicable? All that type of stuff. So it's not an appeal, as a lot of people think it is. It's a way to challenge the way a decision was made. Actually, I got one yesterday. I do planning as well. And we got leave to challenge a board Panola over right to light and not taking into account energy sustainability. Our argument was, well, you should have taken into account legislation, and we got permission to do that yesterday.
So when you say you got leave, it's usually a two-part process where you apply first to get leave to take the application, is it?
Yes, this is turning into a judicial review lecture.
Yeah.
I lecture at Griffith College.
Oh, right, very good. Well, listen, very interesting.
Stages in judicial review. The first one is where you have to get permission you go to the court and go, hello, I'd like to take proceedings against somebody. We just say, the Minister for Social Protection or Minister for Health. And you have to lay out your case, why you're taking it, the basis you're taking it, the lawful grounds of your judicial review, your application, and a judge reviews it. And the reason that leave stage was brought in was to stop, well, basically anybody complaining over any decision. There was a lot of problems, I think the 80s, 90s, about certain litigants, and I think any constitutional solicitor knows who I'm referring to, who just kept taking cases against the state. So they brought in this procedure to kind of stagger proceedings against the states in order to make sure, look, is there a valid claim there? So when you're just reviewing the first stage is the lead stage or permission stage. And if you pass that, generally speaking, this is a generalization, you would have a stateable case then, because that's a test. If a judge will go through your proofs and evidence and your affidavits and see whether or not you have a stateable case. That's a test. And there's other grounds, but that's the main test. And if you have a stateable case, well, then it's a case that has a chance of succeeding. Maybe, it's not going to win, a guarantee to win, but it's a chance of succeeding. And it's enough that the court recognises that is enough to take it to the next stage.
Yeah.
Usually, generally speaking, if you've passed the lead stage, it's a good positive sign that you've got a case that is strong enough to go to lead stage. To go to the full trial. Otherwise, why would you bother taking it?
Yeah.
Excuse me.
Oh, thanks very much for that. That's actually, but you're here today actually to just talk about data protection. So data protection is kind of a buzzword the last couple of years. Obviously data, this isn't something it's going back historic. Why is it so prevalent or so at the forefront of things we do in the last couple of years?
Well, quite a lot. I lecture on data protection, so I go back to 1981 directives if you want. But long story short, we had the first major e-directive about privacy was 1995, the privacy directive, and as a result of that brought in special categories of personal data about data relating to sexual orientation, health, various different categories, cultural, that type of thing. And around 2003, we amended our Data Protection Act to bring those new special categories of personal data. Since then, and that was 2003, but between around 1995 to around 2003, the internet happened. It kind of blew up. Nobody really was online around 95, 97. By year 2000, we had a lot going on. And as a result of that, the 1995 directive wasn't enough. It didn't apply to a lot of electronic service providers. We did have the old electronics, the e-privacy directive, which dealt with telecom service providers, communication service providers, which was all about data protection for telecoms companies. But that didn't apply to the likes of WhatsApp or at the time ICQ Messenger, Facebook Messenger. So another piece of European legislation brought in for that. The difficulty with that is it created a double tier system. Without getting too complicated into it, all of a sudden in the early noughties, you had a lot of personal data online, could easily accessible, but didn't quite fit into certain directives or certain legislation. So you could use or process somebody's personal data for one thing, but you couldn't for another. And there was loads of these gaps. And the whole point of GDPR was that on a certain date, the 25th of May 2018, there'd be a standard rule across all of Europe, and it would all change on the same day, and it would all be the exact same. That was the whole point of it. Before that, each individual country could apply their own rules, and that's why we had so many different rules in different places.
That dictated how companies hold information belonging to clients or individuals.
It did, and again, it depended on what type of company you were, what you were using it for. We had 2011 regulations in Ireland dealing with unsolicited phone calls, text messages, but that doesn't quite fit into GDPR. It's a bit complicated. But without getting into the whole jigs and reels of it, the whole point of GDPR was going to be a standard across the board and it would apply to everything equally and it would start everything afresh. And because of that, it leveled the playing field for everybody. So companies, telecom providers, everybody. Now there is new e-privacy regulations coming in that will deal with electronic communications providers, and that's coming down the line. But for the moment, GDPR sets a level playing field and everybody knows their rights and they're applied equally in every country in Europe. That's the whole point of it. So you could just sue somebody in one country for breaching another.
Okay. And so when there are breaches in GDPR data protection, what avenues are open to somebody?
Well, I don't recommend suing people. The big thing is, obviously that's a disclaimer, that's a joke, we don't go straight into suing people. GDPR came before the 25th of May. The Irish Data Protection Act 2018 kind of gave fleshed out certain things, and one of them was the reliefs available under GDPR. Now, under the Irish Data Protection Act, you can make a complaint to the Data Protection Commissioner. You can, and that would be like a civil complaint if you wanted to make a complaint. You can also, if you wish, make a criminal complaint. Now, there's no distinction, I just want to clarify, there's no distinction in the Act about a civil or criminal complaint to the Data Protection Commissioner, but the Commissioner is actually wearing two hats. They're wearing a regulatory hat where they can investigate and prosecute, but they're also wearing kind of the piecemeal hat, as I call it, where the Commission is entitled to make recommendations or suggestions to a party to try and make a settlement or offer to resolve it. So they kind of wear, as I call it, the mediation hat and also the criminal hat. On top of that, you've got the ability at the same time, without prejudice, to make the complaint to the Commissioner. You can actually initiate proceedings for a data protection action if you so wish. So you can go to the Commissioner, you can issue proceedings, or you can vote. Or not. If you don't do anything, you can obviously not do anything. But you have the option of issue proceedings if you want for a data protection action.
And what are the typical type of breaches that someone might cite? Like what about someone that sends like an email accidentally to another party, releasing someone's details, or some post going to someone else's house? Or are they the type of things that litigation would take from? Or what examples are a breach these days?
Well, there's the big breaches in the paper, that was reported in the media over the last few months. Last year, I think Aircom had a breach. I think a laptop went missing and a lot of data was on that about personal accounts. That was a big thing. I think that was September last year. But that would be something where, now I'm not involved in any of those matters, but that would be something that was reported in the papers, and it was quite sensitive data about accounts, that type of details. Ticketmaster had a breach a year or two ago, I think it was June 2018. That's being litigated at the moment, where somebody had unauthorized access to name, email accounts, that type of thing. I think there was issues relating to credit card details as well. And at the moment, there's a class action lawsuit in the UK over Ticketmaster. Now, the most people watching this show hopefully won't be subject to class action lawsuits, but the typical breaches, I call them, like the very small stuff, will be sending an email to the wrong person, CCing stuff. It really depends on what happens next. Because what a data controller or processor is supposed to do is, once they realize there's a breach, they're supposed to investigate it, and then, where applicable, report the breach, and where required, report it to data subjects. But in order to do that, you've got to assess, well, what level of risk is it? And the difficulty with this is the level of risk is very self-imposed, it's very open to interpretation. If you're investigating your breach, you have to assign a certain risk level to it. And at that risk, if there's any risk to a data subject, you have to notify the Data Protection Commissioner. If there's any high risk to data subjects, well, then you have to notify the data subjects. The difficulty is, well, what's high risk? What's any risk? What's low risk? You might look at something and go, well, that's low risk. I might look and go, well, it's high risk. There's no real clarification as to the levels of risk. It's very much open to interpretation. So that's step one. Step two is if you do have to report a breach to a data subject, well, basically, you're giving them evidence used against you. So the whole issue of you're actually mandated under the Data Protection Act 2018 and Commissioner's guidelines to report a data breach where it's a high risk of injury or loss or damage to data subjects. You have to report it to the data subjects, but you're basically giving them evidence used against you. So that's a proof required, but you're being forced to give it to them. And we're getting into issues of, well, right to silence, the whole kind of self-incrimination issues. That's a big area that I think is going to explode later. As to 1 second, if I'm being forced to give somebody information that could be used against you, and it's an offence for me not to do it, but by giving them information I could be charged with a criminal offence, is that not self-incrimination? We're getting into really weird areas here. Also, on top of that, a state body basically forcing you to arguably, I said arguably forcing you to give information that could be used to prosecute you. I mean, could you imagine the guards doing that? I mean, yes, they're entitled to do that under legislation for specific offences, but we're talking about, very specific offences where, upon my reading of Data Protection Act, I don't think they do that.
And then if you are successful in one of those, a claim for a data breach, what's some question over the damages that might be awarded to you? Is there some difference between material and non-material damages?
Yes. If you have a data protection action, you take the claim. Most claims so far, in my experience, people have been looking for to vindicate their rights. So they've been seeking some sort of declaration and damages. So most of the claims I've dealt with so far are equity civil bills. So they're looking for a declaratory relief as well. Now, the damages under the old legislation, the 1998-2003 Data Protection Act, if you suffered a breach and you're taking a data protection action with the old legislation, you would have to prove some sort of material damage. So you'd have to prove some sort of physical loss or tangible loss or something that is recognised by the courts as being severe enough to warrant material damage, such as a psychiatric injury, such as a medical report, such as statements in your credit card where your identity was stolen. It's something that you can prove. Whereas under GDPR and the Data Protection Act 2018, you are entitled for compensation for material and non-material loss. So non-material loss will be your general pain and suffering for non-specified, for general damages. So it's very much open to interpretation as, of course, how it's going to deal with it. Because right now, as we stand, there has been no case on this. It's been nearly 2 years after GDPR has come into force. There has been data protection actions, but in my experience, most of them settled because no company wants to be defending the first data protection action because it's going to open them up, one, to very bad negative publicity, and two, if they've had a data breach, well, it's going to open the floodgates. So it's going to open the floodgates for everybody as soon as it becomes publicised. So no company wants to be the first one. And because nobody wants to be the first one, there is no court ruling or precedent as to an appropriate level of damages. So it's a very strange position, but a very exciting position at the moment. We just don't know how much it's worth.
Yeah,
very much on a case-by-case basis.
And it seems as the longer it goes on, data protection, you seem to be peeling back the onion of where areas that in life that it affects, especially in kind of the legal stratosphere where, say, in a personal injury claim, I know we spoke briefly on this beforehand, where, say, an insurance company is defending a claim and they might hire someone like a private investigator to follow a plaintiff in an action. Where was there possible data protection breaches in that?
Well, basically data protection affects everything now. I mean, absolutely everything. Personal injury is the prime example, being where a plaintiff would make a claim, and usually the defendant's insurance company would get involved. And for the higher level claims, they do an investigation, and they're entitled to do that. And you're entitled to process information as long as you do it in accordance with GDPR and Data Protection Act. The difficulty is when you start outsourcing certain things, your processors, such as private detectives, mightn't follow or be as conscious or familiar with GDPR as, we say, a high-level multinational insurance company. So their processors, their agents might be breaching legislation. And I see this as a chain of evidence, like with the evidence in a criminal offence, except I call it the chain of data protection evidence, where you identify the first point, well, what's your legal basis or lawful basis for doing something with legislation, and then you follow the chain to the end result and go, right, what's your lawful basis along the whole process, and what stages were you entitled to outsource or refer it, how was the data processed, was it all processed from the European Union? If not, well, then sections of GDPR apply. It's a whole Pandora's box that can be opened up. And the difficulty with insurance companies are, especially with a lot of the smaller private investigators, they just simply don't know how to deal with this. And respectfully, a lot of people simply don't know how GDPR works. It's because it's massive. It is very complicated. It's very complicated. The intrinsities of it, nuances of where data protection applies over, say, personal injuries, and you know, the point at which it becomes, well, you're allowed to do this, but then all of a sudden you nudge over into a breach. Hold on a second, now you're breaching the principles of data protection. Now that's a data breach. From this point on, everything else is invalid. That is the difficulty. That's the point where practitioners have the problem with, because it's very nuanced. But once you understand it, you can use it as a defence and raise it as an objection to introduce evidence as well. So it could be quite a lot. And I had a recent case where, again, it was an insurance company and the private investigators. I got the list of witnesses and went, now hold on a second. Who are all these people, the private investigators? Okay, where's your data protection policy? Where's your privacy impact assessment? Where's all these things? And it's settled. That's
what I was going to ask you. At what point in that chain does either the plaintiff become aware of a possible breach of their data, or at what point do they actually make these inquiries?
Well, I look at this as, and this is more strategic now, we're getting into strategic litigation. When I get data protection actions, I get a lot of them from various firms. The first thing I do is I obviously go through it to see the current position, but I also look at ones like, are there any weaknesses here? And with some cases, you send a 10-day warning letter and start the proceedings. But with a lot of other cases, you look and go, hold on a second, they're missing bits here. I want to do a data access request. I want to get the information. I want to get their policy. I want to get this and the other. Because you notice where usually doesn't fall from one issue, it'll have a knock-on effect on somewhere else. So the whole thing collapses. And I've also, in cases where it's just personal injury or employment cases, I look at this and go, hold on a second, there's data protection action. Now we have two causes of action. And that brings people to the table a lot more, especially, and like I said, with data protection actions, a lot of people simply don't know how to defend them or prosecute them or litigate them because they're so complicated. But when you do, it's very focused. It's like a sniper just going in, take a specific shot at a specific section, and that's it. You just move on to the next one. So your litigation is bang, 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 bang. You break the chain and everything falls apart. And usually if you break the chain, not only does everything fall apart, you've also got a data protection action. So you do a complete 180, especially with defences. I mean, if you discover that as a defendant, if you can actually break the plaintiff's processing, you break the chain, and all of a sudden you can actually do a U-turn and sue them for breach of data protection. So it can be quite good. And the difficulty is, it's not just, and I'm not trying to, I'm just putting this out there, arguably, and this is an argument that's going to happen, solicitors are going to be the next people involved in all this because they're the ones who are processing the data on behalf of their clients. And a lot of solicitors don't have their data protection practices, policies, etc. in order. So, but if you're litigating against somebody and their solicitor has access to information, that's a weakness. Now, I haven't explored that yet, but a lot of people are kind of looking at the solicitors as being the next target, because if they're processing their client's data incorrectly, well, that's a data breach. You know, that's what legislation says. So that's an area that's going to come up next, I think, and barristers, obviously. But I can't talk about anybody else. I know my stuff is airtight at this stage. But you get the point. You have to examine everything in the chain, and unfortunately, legal professionals are people in the chain too. So
where does a possible data protection breach then happen in employment law claims?
Oh, completely. I mean, I use it all the time. Imagine, any employment claim, 99% of the time there's going to be some sort of grievance disciplinary procedure. I think that's a fair point, isn't it? I mean, any employment claim, you have a dispute between two parties. So the employer is generally going to initiate some form of grievance investigation or disciplinary procedure. And by doing that, you're processing personal data. So especially in the investigation phase or grievance phase. So if I have a client who is subjected to a grievance procedure, which, by the way, employers are fully entitled to do. We're not suggesting they're not. But that has to be handled correctly. It has to be done in accordance with GDPR Data Protection Act. And if it's not, well, that's a breach. It's a data protection action. And arguably the results of that investigation, grievance procedure collapses. So if that grievance procedure collapses and they move on to a disciplinary procedure, which is also invalid, and they get dismissed as a result, what's that? Unfair dismissal. So this is being brought into WRC quite a bit. Now, in my experience, the WRC, Workplace Relations Commission, obviously they do not investigate data protection actions. They're not investigating breaches of data protection. However, it is relevant when you start getting into how an investigation was investigated, whether a grievance or disciplinary matter was in accordance with Constitution, natural justice and due process. If there was a data breach, well then it can't be in accordance with due process because it's a breach of the law. On top of that, I've also had a couple of cases where ongoing invasions of privacy, gossiping, subject to bullying, that type of thing, but where personal data is being processed, like gossiping, access to HR files, that type of stuff, that's a data breach. It's breach of GDPR Data Protection Act, but it's also grounds for bullying. It's also grounds for bullying at the WRC, and they've accepted that in cases I've been before them, where they accept that, yes, interference of privacy or effectively breach of data protection, confidence can be bullying under certain circumstances. So it can be used as bullying and also to set up for a unfair dismissal or constructive dismissal. On top of that, I've also had matters where people complain about one second, GDPR, my data protection rights are being breached, GDPR is being affected, and the employer doesn't do anything, or they get punished as a result, and there's your protected disclosure. So, I mean, you can, if you know it, and you can really get into it, detail, and flesh it out, you could probably find an additional grounds of action there. And when you tell a solicitor that, they love it because that's not their case.
And then I know you touched on it briefly at the start there, but when you're actually, if you feel you have a data protection issue or a breach and you want to take a claim, should you go to the Data Protection Commissioner? Should you go to the Circuit Court? Should you do both? What is the best choice of venue, or how do you decide?
Well, it's entirely up to yourself. It's up to the client. It's always up to the client, and I give them the options. You can go to the Data Protection Commission. I myself have gone to the Data Protection Commission my own with a personal complaint, and it's taken years. So no disrespect to them, but they are very far behind schedule. Their difficulties investigating, and from my experience and from dealing with, and this might be anecdotal, so please don't take this as gospel. From my experience as a complainant, and also from my experience from dealing with people who have been the subject of complaints and reading their complaints, going through it and providing advice on it, sometimes the Data Protection Commissioner doesn't actually give a ruling. They give a if hypothetically, David, if you were complaining against me that I didn't comply with a Section 91 data access request, I didn't give you the information, and you complained to the commissioner, and then I said, okay, I'm sorry about that. Here's the information. They may just say, right, that matter's been resolved now. Thanks very much. We're closing the file. Any objections to that? And you're going, hold on a second, David. The point of this complaint was I want a ruling. I want a statement or an acknowledgement that my data protection rights were breached. I don't want you just to close the file. I want you to actually issue a ruling. And that's a little bit of a difficulty because they're so because they're so busy, they can't get that at times, in my view. And also, people don't want to wait years for it. And again, I think that's a funding issue. But again, that's anecdotal. That's just my interpretation and my experience. However, if you want to take legal action, the only two venues are the Circuit Court or High Court, because the Data Protection Act specifically says Circuit Court or where applicable High Court. You can't take it in the District Court. The District Court does not have jurisdiction to hear data protection actions. So you would issue proceedings, 10-day warning letter, and issue proceedings most times in, the Circuit Court, and you would be entitled to some sort of damages. Now, if you have material damage, if you've got specific losses that you could identify and prove, that will only increase the quantum of damage. But that's very much on a case-by-case basis. But in my view, it is similar to trespass. It's similar to some of the landlord torts. You're entitled to something by virtue of the fact it occurred. So the question is, well, how much is that worth? Well, that's very much on a case-by-case basis.
Okay, William, listen, thank you very much for your time. That's been a really interesting conversation here today.
Oh, thank you.
I never asked you there at the start, how are you coping with the COVID-19 disruption and the whole courts?
Great, because I'm getting tons of data protection actions. There's lots of, because a lot of people have moved from the physical office to online, there's a lot more inquiries being made about, obviously, data protection. Now, not only do I practice in this area, I run my own data protection consultancy firm, so Argent Business Consultants. We deal with data protection employment in the workplace. And as a result of that, we've got twofold. We've got the first side, where organizations all of a sudden are scrambling to kind of go, we need to get our policies and procedures in place. On the flip side, we get a lot more breaches, and the breaches won't have to be reported within 72 hours or it's an offence. So you have a data breach, it has to be reported in 72 hours where applicable. And secondly, now we have to notify data subjects. Are we now going to be sued? Are we facing data protection actions? And a lot of solicitors are getting a lot more familiar with them because, well, imagine, let's say hypothetically, actually, no, let's not. We'll say, actually, this is true. Twitter, the Data Protection Commissioner recently issued a notice that they're investigating Twitter, that's going to be released soon. I think WhatsApp and Facebook is going to be released in a few months' time. Now, could you imagine hypothetically if one of those big companies had a data breach, and we'll say hypothetically Facebook, and Facebook had a data breach and they had to notify, you would say, all their Facebook users in Ireland. Now, how many Facebook users are in Ireland? Probably quite a lot. So each one of them would have a data protection action. So could you imagine the customer base there? All of a sudden, every solicitor would be sticking up ads online looking for data protection actions.
I know,
and
yeah,
that's the way it's heading.
Yeah. I get the point. And what do you think about these, when do you think the courts are going to reopen?
Well, they started on a phase basis. I was in yesterday for a leave application judicial review, but it was limited. Court 6 was limited to only 8 people.
Okay.
We were giving a time, and we had to wait outside. They were called in. I have to say they handled. I've only been in a couple of courts.
Yeah.
They handled it quite well.
Yeah.
They blocked off a lot of chairs. The only thing I didn't like was the barristers' tea room. Now, for those of you who don't know, it's a private den of sorts with doilies, and you go in to get a coffee and be happy barrister. But what they've done is they've blocked off the entire thing. So it's a queuing system.
Okay.
Instead of tables and chairs, we've got a queuing system like Alton Towers. They are called, you go up and get a coffee to walk out.
Okay.
So that was the only negative thing. But in terms of the courts, it was positive. They were doing very well.
Yeah.
The central office, a lot of things are on general adjournment for the High Court stuff. So you'll have to re-enter them. And that'll be fine. You need an excuse to re-enter. I don't think courts would be too happy if you started shoving everything in now, let it stagger, and follow the practice directives. Keep updating practitioners on the website. So follow the updated directives, and I think it's going to be fine. I think it will be a backlog. It will be slow, and David, as you probably experienced yourself, there's probably a drop in like litigants coming in the door or clients making inquiries. I know from us listeners I'm dealing with, they're just not getting the trip and falls, not getting the vendors. Nothing's really happening. It's also in employment claims, nothing's really happening because everybody's holding off on what's going to happen. I think when when we get back to work and the restrictions are lifted, I think there's going to be a load of litigation on employment side of it, and also on health and safety in the workplace, personal injuries, because I think there's going to be huge challenges of whether or not my employer gave me the proper protective equipment, whether or not it was necessary for me to come in, whether or not social distance, etc., etc., etc. And if there was a breach in that, well, then there's a strong grounds for a personal injury case. So I think there's going to be a lot of them coming up soon, along with data protection actions. But as soon as Facebook or WhatsApp or somebody or Twitter has a big data breach, every solicitor is going to be sticking up ads online looking for data breaches.
William, thank you very much for your time. One last question for you. If there's any young legal graduates who want to have a career in King's Inn and to be a barrister, what advice would you give them starting out?
Run away. Don't do it. Oh God, I get asked this a lot. Like when I was going to the King's Inns, it was kind of like you'd need to take around 5 years in order for it to kind of start practicing and to get clients and to make a basic minimum wage. Now you're looking at 10 years.
Really? Okay.
Yeah, it's just simply not there. There's too many people. There's not enough work, and there's solicitors. I mean, you know this yourself. Solicitors are kind of, and I don't mean any disrespect for this, by the way, David, but solicitors are kind of edging into the barrister role, doing more advocacy, doing more drafting. So what traditionally would have been the barrister's job, or we'll say low-level circuit court work, which would be around 10 grand, 15 grand. Well, now that's obviously district court, since the quantum was raised in the district court. So, solicitors are just dealing with that. So there's a chunk of work gone. Every time there is a state body investigates or does something, it seems that they're introducing more and more reasons not to go to litigation. Mediation Act, which some people are now using as a weapon, where we haven't got to the Mediation Act, we're going to challenge you over costs of that. Which actually I lecture mediation at Griffith, which is, this whole area is a bit of a mess too. I would advise somebody, if they really want to do it, to kind of have a backup plan, do lecturing, do work somewhere else. Do it because you enjoy it, but you're not going to make a living off it for
straight away.
God knows how long. And I have to be honest with you, you're not.
Yeah.
It can be great, rewarding, can be fun, but you're not going to make a living off it.
Well, listen, thank you very much for your honesty, and thank you very much for your time today. That's been a really interesting conversation, William. And look, we wish you all the very best in the future. Thank you.
Cool. Thank you so much for having me. It was great fun.